Basically, a copyright is a type of intellectual property right that actually protects works of authorship, other written creative works or ideas that have actually come to fruition by an author. The bottom line is that copyrights generally will arise by law. So if you've created a presentation, if you've developed a trade process, if you have actually written a book or something along those lines, you should know that to a certain extent at law you may be able to simply put the small c by your the title of your work to indicate to the world that this is something that you own the rights to. However, what you should know is that it isn't necessarily yours unless and until you actually file with the U.S. Copyright Office an application and subsequently register your copyright to let the world know formally that this is your copyrightable work. With respect to freelancers, one of the biggest issues that you're going to have is that if you're hiring people to actually do work for you as a freelance artist, as a freelance author, anyone who will be bringing into fruition as a result of your agreement with them some sort of creative work, that they may have an entitlement or claim to the creative work that arises even though you contracted for them to do that. The way that you would actually protect yourself against freelancers that you hire to produce works for you, creative works for you, is to include a work made for hire provision that recognizes the applicable state and other laws that may come into play to determine whether or not you are actually the rightful owner of the copyrighted materials that your freelance artist, author, or what have you may be making while you are paying them to do so.